Seen you in a long time.
Oh, good morning.
Good morning. If it please the court, my name is Richard Walsh. I'm from Horing, Wellickson, Rosen, DeGrugier. I represent the appellant. I'll get right to...
Slow it down and louder into the microphone, because they got to hear you out there.
They'll tell me. I'm known for speaking very quickly, so
Okay.
I will take a deep
Just
breath.
slow it down and tell us what you want to say.
It's our client's contention that because it was in the low-income housing tax credit program and it was an active condominium conversion.
Well, the question of the condominium was something that I dwelled on when I looked at this. You became a condominium. You went through the procedures of that conversion, but you didn't act as a condominium. You acted as a rental unit. There's not one. All of the units were not sold to individuals, which is basically the intent of creating subdivided units and selling them off. You treated this your clients treated this building as if it was a rental building. And I think the city took it as a de facto concession, if you will, that you were seeking subsidies for a rental building, and therefore you weren't in compliance. So that's basically where they came down, where you attempted to raise the rents without permission, et cetera, et cetera. Tell me what's different.
Well, for one thing, the Department of Finance recognized the property as being condominium units.
No, it was established de jure as a condominium.
Right.
But you didn't act like a condominium. You acted like a rental unit. That's my point.
Your Honor, the point, we don't know why the prior owner didn't actively market it. I can guess. For example, at the time, people didn't want to buy a condo unit in this area, so they didn't do it. There were other areas that were better purchases. The market wasn't what it was back in the day.
Right? Loft conversion under that program.
I think it was actually a warehouse conversion.
Warehouse conversion. I'm sorry. Yeah.
But they converted it. They got the J51 as part because they converted property into that, and at the same time they did the condo conversion, and then they couldn't get anywhere with the condo conversion for whatever reason. We don't know why. But again, in my opinion, the market wouldn't support it. That's why they decided that we got to get money in someplace. We can't sit here holding this property. We have to do something. So Related, that owned it at the time, entered into the regulatory agreement. Well, the regulatory agreement didn't specify that these properties had to be made rent stabilized. And the state is perfectly capable of putting that requirement into a regulatory agreement when they enter into a regulatory agreement. I actually presented in the record at page 482 a regulatory agreement with DHCR, or one of the city agencies, I take it back, where they actually required participation in the program. Our contention is that under the J51 statute, and it's what it says, if you're regulated by another program, you don't become rent stabilized. Well, this is clearly regulated by another statutory regimen. The rents are set by the federal government. What we can charge is restricted based upon what FMRs are and income and everything else. The issue is not whether rent stabilization is consistent with or in conflict with the LIHTC program, which is what the court below seemed to think, and I believe DHCR also felt the same way. The issue is whether or not, under the J51 statute, the fact that I am regulated by a different program, I don't have to become rent stabilized. Our contention is that's what we have, and it doesn't matter that rent stabilization can be consistent or inconsistent. It's not irrelevant in this situation with this J51 in place. Some of these tenants became tenants before J51 went in. J51 is now expired. Tenants have moved into the property since the J51 expired. Some have not. At some point, the reality of this situation has to be recognized. I will tell you, and it's outside the record, unfortunately, but since I'm not handling it, it took the Attorney General's office 2.5 years to approve the M10 that my client, the current owner, was filing for purposes of trying to market, to file an amendment to the offering plan. So we only just got a confirmation that it had been approved January. So now we're going to be filing an amendment. Not relevant to the issue here, just background information. As a practical matter, it was a condo. It was converted. They couldn't sell the units for whatever want, so they decided to bring in have some other method of renting the apartments out. Nobody living in this building now is under the threat of being evicted because, one, the regulatory agreement bars anything but a good cause eviction. And the appellate term second department decision in Paycoff versus Harris prohibits the landlord from unconscionable rent increases. So these tenants are still protected from being evicted. It's not as if rent stabilization is necessary.
Yeah, but your opposition is going to say that they should be under the rent stabilization program as opposed to what they're currently under at this point. Or they claim they are under it, but you're not in compliance with it.
That is their position.
That's their argument.
That is their argument. And our argument was we're covered by another regimen.
So
we
you're
don't have
saying,
to.
Hey, we are being regulated. There is a cap. We're protecting low-income residents, et cetera, which is the public request here.
Right. We're regulated under the LAHTC program. We're regulated by the Attorney General's office.
And the question is, are they comparable?
Yes. There's a limitation on what rents you can charge. We're required to rent these apartments to people in certain income levels. Right. That's not a requirement of rent stabilization. In fact, rent stabilization, one of its biggest defects is it doesn't have any provision for protecting low-income people from rent increases. You have hits and misses in places, scree and dree, but that's it. This program, which limits my client's rights to do certain things, qualifies as another regulatory regime for purposes of being exempt from imposing rent stabilization in accordance with the J51 statute. Two grounds. The LIHTC program, which is administered in this state by DHCR, and the existence of the condominium conversion.
Any other questions from the panel?
And one other thing I would point out, which was I figured out when the building first got J51, it was given a 12-year period. When the city agreed that, yes, this is a condominium, they made it a 14-year period. So clearly, there was no immediate benefit from converting to condo, I should say. But the city recognized it and adjusted the benefits period for that purpose.
Well, both have expired now, right?
Under the 12-year period, initial 12-year period, and under the 14th, it's expired.
Yeah.
Thank you, Mr. Walsh.
Thank you, Your Honor.
Good morning. May it please the court. Jason Parpis for DHCR. I don't even know where to begin. Let me start off with the law. J51 requires that a property obtaining the tax abatement benefits from the J51 program be subject to regulation under 5 different systems specified specifically by the law. Rent control, either the Emergency Tenant Control Act or the New York City Rent Control Law, a PHFL, private housing finance law.
Slow it down and louder.
I'm sorry, a private housing finance law, a program, PHFL, a state program, or a program, a federal program that's supervised by the Housing Urban Development, Department of Housing and Urban Development federal program. Low-income housing tax credits are controlled only by the IRS, the Treasury Department. Specifically by the law, they are not the same as a HUD program. And there's a reason why. J51 is a program that is generally intended to maintain and uphold the housing stock. The LIHTC is intended to create new properties. LIHTC is intended to bring in financing to build properties, to build new low-income and affordable housing. J51 is to maintain the stock or to improve areas that were blighted, have blight. They're not the same thing. So off the start, they're not complying with the J51 when they knowingly and intentionally and willingly accepted the J51.
What significance, if any, is there whether they're a condominium or just a regular rental building? The condominium, they're not a condominium. They didn't. Or are they not granted condominium status, yes or no?
They did not effectuate, this is off the record, they did not
Not
consummate.
off the record.
I'm
On
sorry,
the record, were they not considered a condominium, yes or no?
They did not consummate their condominium status. They did not have any sales. They did not consummate, they did not become, they were granted condominiums.
Before you can sell,
Yes,
you are determined to be, in this instance, they applied to be a condominium, okay?
yes.
Were they granted that, yes or no?
I believe they were.
Okay.
I believe they were. However, again, that does not.
De jure, they're a condominium, okay? How they acted is another issue, but what significance was my question, was there between them being a condominium and not being a condominium as to the regulatory overlay that you speak of?
The fact that they may be legally considered condominiums, but the effect is that they're a landlord. They're a development still. 70 units are owned by the landlord. They're not. They don't have the protect. They're not acting like a condominium. So they're using the shield of a condominium.
That's how I opened with him. I just wanted to see if you confirmed it and what significance there is between a straight rental building and a condominium building that is renting to their apartments.
The difference is that a condominium, and this is with the rent stabilization law, Your Honor, the rent stabilization law says that it will not be applicable if there's a conversion from residential apartment to a condominium. So what they're saying is that we're trying to protect homeowners. And this is not a homeowner situation. This is a landlord situation. This is a situation where the landlord is not a single person or even a group, let's say a partnership, that owns a couple of condominiums. This is a landlord that owns the entire building, all the apartments in the building.
So that's the differential? That's what I'm trying to get out of you.
No, I'm going to stick to the law, Your Honor, that they did not.
I think we're going to do that too.
No, I understand.
Why don't you answer
Please,
my
I'm not trying to be facetious. I'm just trying to. What I'm saying, Your Honor, is that they intentionally went and got J51 benefits. They knew what the law was. They can't say that we have a regulatory agreement with DHCR when they went and got the J51 agreements. You can't say I'm going to do what you want me to do and then not do what I'm supposed to do. They're not fulfilling their obligations pursuant to the law. They're not fulfilling their obligations pursuant to LIHTC. You have two systems. It's easy to comply with both. LIHTC and rent stabilization law J51 are not at odds. LIHTC does not preempt J51, does not preempt the rent stabilization law. They're both in tandem. They work together to support the affordable housing market. Like I said, one has stricter requirements, then you have to apply by those stricter requirements. There's cases that I cited, and I do rely more on my case. Obviously, I will try to answer your questions as best I can on my submissions. Bracero says that the two laws do not contradict each other. The Congress did not say LIHTC is supposed to preempt any state law. Congress is not trying to infringe and shut out any state law, and there's no conflict in applying both laws. And even the cases that didn't apply Bracero, the courts did not apply LIHTC or rent stabilization law when it was being used as a weapon against the tenant. It was being weaponized to reduce rights of a tenant, where an owner was trying to avoid its obligations. That's my understanding of the law, Your Honor.
Thank you.
Thank you. I don't need any more coffee. Have a good day.
Thank you. So in a moment, we have the Duncan matter. After that, we have Kylie. Good morning.
Good morning. May it please the court, Benjamin Goldstein on behalf of the plaintiff appellant. Good morning, Your Honors. It is plaintiff's central argument in this matter that the defendant owed the plaintiff a duty of care